All right. Well, good afternoon, everyone. Pleasure to be with you all today. My name is Richard Waring. I live in Charleston, and I'm an attorney in the area, and done some work with nonprofits, chambers of commerce, done some work in higher education, and one thing that kind of falls in line with all of them is the importance of understanding contracts, especially in the small business space. Is something that can be um, a really good friend or a really bad enemy to you. So today we're just going to take some time and kind of go through the fundamentals of contracts. Bear in mind, there's a lot of information regarding contracts, so we're going to kind of go high level today. Um, I asked Ms. Cooper if in the future, if you guys are okay with it, if you want to do a follow-up session or if you have more detailed questions, um, please take my email address off this page right here. Feel free to email me at any time with any questions. If I can be of help, I'll be glad to do so. And if I can't be of help, I'll refer you to someone who can. So with that in mind, we'll move forward. Is it moving for you, Ms. Cooper?
Do you see the PowerPoint slide?
It hadn't advanced for me.
Okay.
It's still on the first page. All right, there we go. All right. So today's agenda, like I said, very high level. We'll run through a couple things. We'll start off with a quick scenario. We'll talk about why contracts matter. Very important part of contract law is formation. Do we even have a contract? Was a contract established? Those all fall under formation. We'll talk about consideration, which is another often misunderstood piece of contract law. We'll talk about what happens in the event of a breach. We'll talk about remedies when there is a breach. How do we make ourselves right? How do we make ourselves whole? And then we'll take a look at something that isn't specifically contract law, but it does fall in line with it. It's kind of an intersection between civil procedure and contract law, which is a minimum contacts and purposeful availment. And then we'll take some questions at the end. I say we'll take questions at the end. If I say anything that brings up a burning question for you, please feel free to jump in. Let's make this as interactive as possible. I'm sure Ms. Cooper is going to probably man the chat. And, if you have a question right in a moment, please raise your hand and unmute yourself and we'll go from there. Okay? All right, we can move forward. All right, so quick scenario, very high level, kind of simple, not always as much. All right, so let's take a second and kind of read over the scenario. Jasmine owns a small business, Pixel Bloom, and she agrees to do some design branding for Sweet Crumbs Bakery. There wasn't a contract signed. All right, so kind of a handshake agreement. Ms. Foster, I see your picture over there. So, Ms. Foster, me and you know each other. We've been friends for a while. You got a business, I got a business. My business does advertising, you provide a service. And what I want to do is say, hey, I want to make some money. I want to work with you. And because we know each other, we feel like we don't necessarily need a contract. Happens, right? All right. So, what
Right.
goes wrong? The baker, the bakery, Sweet Crumbs Bakery, refuses full payment, citing dissatisfaction with the work. Oh man, that's kind of crazy, right? We're friends, we know each other, we're in the same business ecosystem, but now you're saying you don't like the work I do. All right. There were no written terms to enforce payment or, more importantly, the scope. So if I don't know the scope of the contract, how do I know that I'm operating in a way that's acceptable to you? Right? You're kind of leaving it up to me to interpret what I think you may want versus you laying out the plans and procedures saying, hey, at the end of 60 days, I want my website to do, I want 6,000 views. I want to be on Instagram TikTok, Facebook, whatever else. I want 2 YouTube ads. I want to be very specific in what I ask for in my scope, because if not, I'm gonna put something out there and I want you to pay me. Also, not only is the work not acceptable to Sweet Crumbs Bakery, but she's starting to get negative reviews. All right. Hey, Ms. Wilson in Columbia. All right. So, any thoughts so far on what we have here? And Ms. Cooper, are they able to come off the mute as they want to, or do you have to unmute them?
Okay.
Okay. All right. Anybody, any thoughts?
Got a mess.
Got a mess. Tell me why you got a mess.
Because there was no contract. There was nothing that stated the boundaries, what should be what in case of whatever that's happening. They just went along with the program, thinking that everything would be great, because they know each other, because they've been around the same circles, this, that, the other.
Yeah.
But they should never assume that things would be great.
Ms. Wilson, that's very intuitive. You're right on point. Now let me ask you a tough question. Who's wrong? Can we determine who's wrong so far?
Actually, to me, they're both wrong, because they both should have something in place with each other. If one doesn't, if one has it and the other one doesn't, the one that has it should say, listen, I know we're good friends. I know we hang together and everything, but just a word of advice, I think you should have something in place, a contract in place, stating, when you do business with all kinds of businesses, it doesn't matter what, including myself, what is not, what should be, what should not be, etc.
I like it. Yeah, you're my A student right now, Ms. Wilson. We're gonna see if anybody else will step up to the plate and challenge you. Ms. Cooper, can we go forward to the next slide? Let's see if Ms. Wilson is right here. All right. So the impact of this, right? So we got a conflict, right? Law is all about tension. Somebody's saying one thing, somebody else is saying something else. There's a tension. We got to come to some middle ground. The impact to the bakery, financial loss, perhaps, right? She's starting to get negative reviews. Pixel Bloom did some work for the bakery and they haven't been paid. Now let's assume these are 2 small businesses, right? They may be, they may not be. But like, how much impact does financial loss cause, and how much financial loss and loss of time does unpaid work cause? Those are heavy, right? You can't spend 20, 30 hours on a project for it to come to nothing, right? I'm sure you got your budgets balanced on that, is baked into your salary and your payroll and all of those things. So when you do some work, you want to be paid for it. You want to be paid for it in a timely manner. Time wasted on disputes. Anybody think there might have been some dialogue between Pixel Bloom and Sweet Crumbs Bakery? Some of it might have been gentle, some of it might have not been, might have started arguing. Well, I did such, and this. Yeah, but your work is trash. My work is trash. Oh no, we're not doing this. Emotional stress, lost clients for both of them, right? Pixel Bloom's reputation is being based on the work they're doing, because we know with the power of social media, all it takes is the click of a button and you can kind of ruin somebody's whole reputation, right? Both ways. Ms. Wilson, you got any additional thoughts on this? I'm gonna pick on you and then you can pick on somebody else. You can pick anybody you want to help you out with this, all right? Any thoughts on the impact of this so far?
It's devastating to both businesses, actually, because they're small businesses. And it could have been just so simple to just, write out something up front, or be upfront with each other and make sure that they had some kind of contract or something in place for this,
Absolutely.
Yeah.
You're spot on. You're spot on. And I think one thing that we can take away from this in these first couple slides here is that a contract does not need to be a complicated 10-page document. It can be as simple as you want it to be. Uh, it can be as complex as you want it to be, but there needs to be some form of a document that clearly identifies the intent of the parties. Now, South Carolina falls in the Fourth Judicial Circuit. Reason why I say that is because the Fourth Judicial Circuit has a tendency to believe in the formation of a contract. So in the event that a written contract isn't provided, the court is going to take the facts from both sides and do its very best to come up with something that follows the construct of what an acceptable contract is in the state of South Carolina. Does that make sense?
Yes.
All right, somebody give me an amen. Y'all quiet on me today, man. All right, so in the event, so Ms. Wilson, me and you decide to do some work. I'm gonna paint your garage. You're gonna pay me $500, right? We don't write anything down because we know each other. I've watched you grow up, and you bought your first house, and I'm your next door neighbor. I'm an old man, and I'm proud of you. I love the fact to see you buying your own house. And I say, you know what? Let me put a coat of paint on that garage for you, right? And I say, I ain't gonna charge you nothing but $300. Now, we both know $1,000 paint a garage that size, right? Well, I get out there and I start painting, and my paint looks like a 3-year-old, right? And you say, Rich, I'm not paying you for that because now I'm gonna have to go pay somebody to do this over again. And I said, well, no, I already spent 6 hours. You've been watching me paint for the last 3 days. I bought the paint. Um, it's cutting to the little bit of money I'm charging you. No, I don't accept that. I'm gonna sue you for my $300, right? So no contract written. I go to the courthouse and I say I want to sue Ms. Wilson Claims Court for breach of contract. All right, nothing written. We're gonna get our day in court. The judge is gonna say, Mr. Warren, tell me your side. Well, I offered to paint her garage for $300, which is way below market value for that type of work. Ms. Wilson, you would say, yeah, he painted the garage. He did a terrible job. You probably gonna have pictures. You're gonna bring it in. You're gonna say, you know, because of this, I'm gonna have to go hire another painter and pay somebody else to do the work all over again. Nothing in writing. The court is gonna say, okay, Ms. Wilson, you said okay for him to paint your garage for $300, right? You had ample time to tell him that you weren't satisfied with the work that he's done. If indeed that happens, the judge has to make a decision. And then it goes back to all those little kind of nuanced things. Was the work acceptable? Would the work be acceptable to a reasonable person? Is there something specific about your garage that makes it harder to paint than most other things? Is your garage made out of tin or metal, right? And I can't just paint it with regular paint. I got to have some special utensils and tools to do that paint job good, right? All those little subtle things will start coming into play, but the court is going to look to see what's acceptable versus what's not, and they're going to draw their own conclusion as to whether a contract was made. Does that make sense? Does that give anybody a headache?
No.
So the point okay, it doesn't give you a headache. It makes sense to you, Ms. Wilson?
Yes, it does.
Right. So the thing I want you to take away from this slide is, in the event that you have a written contract, you take away the power of the court to interpret something that may not be in your favor. You own the offer. You're the master of the offer. When a contract is written, there's a master of the offer, the person who made the offer for the contract, and then the person who accepts it then becomes the master of the contract, and they'll kind of jostle as long as there aren't any counter offers or anything like that. Any questions so far? All right, we're doing good. All hearts and minds are clear. If so, we can move forward, Ms. Cooper.
We're doing fine. I just want to invite people, if they have questions, they can enter those into the chat as well.
Okay.
Ooh, sorry.
All right. So why contracts matter for small businesses? I think in the scenario, I think you kind of start to see why it can be so important and how it's a level of protection for both parties, right? So, you know, in the example we gave, we were playing around, me and Ms. Wilson, but what if we really were friends, and what if we really were in that situation? Not only are our businesses losing traction, not only are we losing uh, good reputation in the community for doing good work, but also we've put our friendship at jeopardy, right? If we are minority businesses in the same ecosystem and we should be helping and promoting each other, don't forget the relational piece. Don't just look at it as law. Look at the relational piece to this as well. Yeah, it might be a little uncomfortable up front to pull out a piece of paper and say, hey, these are my expectations of you if you take on this work. But then you give the offeree, the person who's accepting or not accepting the contract, the opportunity to look over this and say, okay, this is something that I can deliver on, right? And if they look at it and say, you know what, my time constraints won't allow me to finish this project in the 6 weeks you want it done in, would you consider a counteroffer and allow me 8 weeks to do this work? All those little subtle nuances can be kind of ironed out in that situation, right? So don't look at it as saying, oh, I'm trying to complicate my business, so I'm trying to make this harder than it needs to be. No, it's a level of protection for you, for both parties. It protects a lot. It protects reputation, it protects business continuity, and it protects relationships. All right, so 3 things I want you to take away from this. All right, clarity and expectations. Ms. Wilson, just like you said in your example, we need to kind of hammer out the details of what my expectations are. If I'm paying you to provide me a service, then I need you to provide the service that I'm paying for, right? Um, it just helps us be on the same page as we move forward with the nature of the work being done, right? And we all have contracts. So, I mean, you can say, okay, my business isn't at a point now where I'm, executing contracts. It's not big enough yet. Well, don't even look at that. Look at, do you have a cell phone? My guess would be yes. Uh, what do you expect that cell phone provider to do? Provide you a phone and provide you service, right? What does that cell phone company want in return for providing you a phone and a service? They want you to pay a monthly bill, right? That's a contract. Uh, guys probably got cable. You got water at home, you got electricity. All these things are contracts. So don't think that you don't have any exposure to contracts, because you do. We deal with them all the time. All right. Risk management. Uh, in the event that it is a small business that we're talking about, things that might not be a big concern to a larger entity can make or break a small business. So if you think, okay, my operating budget, I do 12 contracts a year, each of them is $1,000, $12,000 a year is kind of what I'm expecting my business to do. Just a rough example, round numbers, right? If I get into a contract dispute with Ms. Wilson and it takes up 90 days versus 60, well, I've lost a pretty big chunk of my business for that year, when all of that could have been hammered out with the contract. As long as we put some paperwork to it and say, okay, this is my expectation of you, then I give the offeree the opportunity, like I said, to agree or disagree that I can do this scope of work, I can deliver on this project, or you know what, hey, you better off finding somebody else if you need it done in this time. So clarity expectations, you're managing your risk, and then of course the legal protection. Court is uncomfortable, it's timely, you get attorneys involved, it's expensive, and again, you lose all of those things that you had in the beginning that we were trying to protect, right? The relationships, the business ecosystem, the reputation of your businesses, all of that stuff kind of starts to come into limbo. You enter into the judicial system, right? And the justice system, because most of it's public record. So when I filed that lawsuit against Ms. Wilson, guess what? Maybe make a local newspaper. Somebody's probably gonna put it on Facebook. Somebody's probably gonna put it on Instagram. Might have YouTube. Somebody doing a reaction video to it. So you want to protect what you're building, which is, because I know this is a hard thing as much as a mind thing. When an entrepreneur takes that step to make the sacrifices necessary to start a business, it's a head and a heart thing. So protect both aspects of it. All right. What questions we got so far? Miss Wilson, call on somebody for me. They too quiet for me today. Who you got? Who you gonna call on? Call somebody good.
Let's see.
Call somebody who will put up a
Well,
good fight.
oh, a good fight, huh?
A good fight. That's what we're looking for. We're looking for a good fight.
Ooh, I don't know. Um, well, the first person that comes after your name is Angela Jackson, so that's who I'll choose.
Angela Jackson. I was just thinking about you, Miss Jackson.
Hello,
Hey, Miss Jackson,
everyone.
how you doing?
I'm well.
Good to, good to hear from you. Good to hear from you. What questions you got so far about what we've mentioned? Does this make sense? Where are you like a little fuzzy? Talk to me.
Well, I like the points that have been made so as far as a contract, bringing clarity on both parties' expectations, and it's basically a legal protection for both as well.
Hmm.
One of the points that I like that you brought out was that if you are in a contract and it appears that you're not going to be able to complete, which we often hope that doesn't happen, but in a aspect, just being transparent, being upfront, letting them know, what has happened, than just shunning a person or just going ghost on, your partnership. I think that is being a person of integrity. And so I really appreciate you bringing that point out because a lot of times that is not what happens in a small business arena. So I thought that was very interesting. So I appreciate you bringing that point to light.
You know what? I love something you brought up a thought, Miss Jackson, and I knew I was Wilson call on you because you the one. You got it. You the one. They told me about you before you got on the call. I'm teasing. They ain't said nothing about you. But
Okay, good.
in in most states, state law, and sometimes even at the federal level, when something isn't totally clear, there are two standards that can be brought up in contract law, right? The first one is called parole evidence, right? It's not written in the four corners of that document, but what would a reasonable person expect to happen in this situation? And the court will look to course of dealings and what the industry say. So if we jump back to that example where I was painting Ms. Wilson's garage for $300, remember I mentioned, well, what if her garage isn't made out of wood or something I can easily paint or something that a reasonable person could look at and say, you know what, hey, I can paint this, no big deal. What if I start painting in this vinyl siding and the paint doesn't adhere to it properly? Well, what if I didn't know that up front, right?
Right.
Is it reasonable for me to think that, okay, I've been in this neighborhood for the last 20 years. I know the houses are made this way. Maybe I don't know that the last owner, changed the material on the garage and now I can't paint it the way I thought I could, right? Well, instead of me just not showing up for Miss Wilson, what if I go and knock on her door and say, Lisa, I started painting your garage. I noticed that it's not the material that I thought it was. So either A, I can stop what I've done and you can go forward and paint it and has proper materials. Or B, if you can give me like another week or two, let me learn a little bit more about this material and see if I can still complete the job. Does that make sense?
Yes.
Yes, it does.
Right. And then it gives me some options as the offeror, and it gives Ms. Wilson some options as the offeree, right? She could say, you know what, cool, take your time, no big rush. I wasn't gonna get to it till summertime anyway, so take your time. Or she could say, you know what, I'm having a dinner party next week. My family's coming in town. I really would like to have it done. So you know what, stop what you've done right there, and let me find somebody who's more familiar with this situation I got going on with my garage. Does that make sense?
Yes.
All right, good enough. All right, Ms. Jackson, you did so good. Pick somebody for me. Who you got?
Uh-oh.
Get a good one. Find somebody
Okay,
mad for me.
okay. I'm going to go with Will Dunbar.
Oh, I've been waiting on Will. I heard a lot about you, Will. Will, how you doing today, sir? Oh, Will, you got to
As
talk
we
to
wait
me.
on Will, I have a question,
Lay it on
if you
me.
don't mind. All
Sure.
right, so you have two parties and a contract that has been signed by both, but there's also a verbal agreement that
Mhm,
may not be within the contract. So does
mhm.
that verbal agreement, if there is a dispute, does that hold any weight?
Great question. It can. I mentioned a term a few minutes ago called parole evidence, and that's an aspect of the contract that may have been discussed but didn't find its way into the four corners of that document. So when I say four corners of the document, I'm talking about a piece of paper. And Ms. Cooper, you may have asked me to uh, cook the food for your family reunion coming up next Friday. You know, I got a big old grill and I do like some mobile barbecuing events, right? Cool. We agree in the contract that I will cook chicken, ribs, and anybody here eat chitlins besides you, Miss Cooper? All right, maybe not. I'm teasing about the chitlins, but let's just say you
No,
told me.
no,
I'm gonna
thank
say
you.
Will eats chitlins. I'm gonna put it on Will until he comes up.
So let's just say you contracted with me to cook ribs and chicken, right? Cool. In the contract, you're gonna pay me $1,000. I'm gonna cook till everybody's full and fed. Uh, Day of, you pull up and you got 35 pounds of catfish, and you say, "Hey, can you throw this on the grill?" And I say, "No, I'm not equipped to cook that," right? And you say, "Well, I'm paying you all this money to cook this food. Why can't you cook the catfish?" Right? And maybe there's some reason I don't like catfish or my grill's not equipped to cook it the right way. Again, I'm trying to protect my reputation. Um, and you say, well, you know what? I'm not paying you for any of this because you're not doing what I asked you to do. I've hired you to provide a service. You're not performing that service for me. Well, we have a conflict, right? We always say the law looks for tension. The tension on my side is you hired me to cook chicken and ribs, right? The tension for you is, yeah, you're cooking chicken and ribs, but I also want you to cook this fish that I brought because some members of my family really like it, and I want to make this a really good, situation for them. We have a little bit of a conflict, right? Anybody right? Anybody wrong? It depends. But now the dispute, if we end up going to court, is they're gonna say, well, what's in the contract, right? The point I'm trying to get you to see, Ms. Cooper, is whenever there's a change, you want to make an amendment to your contract, right? So if you find out enough time ahead and say, hey, Richard, I know you're cooking the chicken and the ribs for us. Are you also able to do catfish, right? Now, again, I have some options, right? I can say, Ms. Cooper, I don't cook catfish, but I have a partner that does, and I'd be glad to bring him along. Um, may cost you extra $100, but he'll be able to cook all the catfish you want. Or I could say, you know what? Yeah, I just need to bring my other grill for the catfish because you don't cook it on the same grill as you cook chicken and ribs, right? So we give each other options. So whenever there's an opportunity to, you want to amend your contract to pick up all the terms. Now, in the event this went to court, I probably would win that one, Ms. Cooper, because I was there and prepared to cook what was in the four corners of the document, the chicken and the ribs. Um, but again, when there is time enough, you want to add whatever additional terms, because technically what happens is there is a rejection of an offer and then a counter offer is what's happening. Now, if you don't give me a reasonable amount of time, which is the issue in this particular case, then I'll probably win that one. But if you call me a week ahead and say, hey, Richard, can you do this? And I say, yeah, cool. Yeah, maybe we didn't get around to changing the paperwork, but you've given me a reasonable amount of time. And I've also verbally given you a yes. Now you show up day of you know, and I already got the grill rolling, I got the seasonings going, I got the chicken on one side, the ribs on one side. No, I can't put fish on there because it's gonna mess up with everything, right? So, point I'm trying to make, I took the long way home is whenever you can, put those additional terms into the contract because essentially what you are doing is rejecting that original contract to cook the chicken and the ribs, and then a counter offer is being made for me to cook chicken, ribs, and fish. Does that make sense? Right. So whenever you have that, all right, no problem. So whenever there's an offer and a counter offer, again, that whole process of acceptance and rejection goes back into play. So when people start shooting terms back and forth with each other, each time it's a rejection and a counter offer, rejection, counter offer. Ms. Wilson, I could paint your garage for you. I need $500. Richard, I can't pay you but $400. That's a rejection of my offer to paint it for $500 and a counter offer for her to pay me $400 to do it. Now I can accept that. Okay, I can do it for 400, or I can reject it. Man, the paint alone is going to cost me $450. I'm only making $50 for this job. So it gives the person the right to maneuver in the offer is kind of the takeaway there. All right. Do Will ever show up? No Will? Miss Jackson, you might have to call somebody else. I don't know what we're gonna do.
Okay. Let me Miss Norika Edna.
All right. You said Miss Edna?
Edmond, Edmond.
Okay, Miss Edna. Miss
Norika.
Edna, how you doing today? I see your name. Miss Edna, you there? Come off mute if you are. And Miss Cool, if we can go to the next slide, please.
I'm sorry, my mic wouldn't unmute. Can you hear me now?
Yeah, I can hear you now. Good to hear from you, Miss Edna. How you doing today?
I'm good. This is Narika.
All right.
I'm sorry.
Norika.
I am listening to you babysitting my grandson.
Okay. Hey, grandson. How old is he?
He's 4.
Okay, I bet you having your hands full. So I'll tell you what I'm gonna do. I'm gonna let you call on somebody else.
Okay.
And feel free to call on Miss Cooper if you want to as well.
Yeah, because he wants some lunch after school.
Okay, I got you. I want some too. So feel free to call on anybody and don't exclude Miss Cooper. She's in on this as well. So call on whoever you want.
Second. I'm trying to get the list up. 1 sec.
All right. Okay.
One second, baby. Win Davis.
All right. President accounted for? All right, till you show up, we're gonna talk about formation. All right. Now, for a legally binding contract, there are a couple pieces that have to be in place. Excuse me. All right. Offer, acceptance, mutual assent, and legal capacity. Now, offer and acceptance are like the key pieces. Before a contract even starts, generally, there is some type of conversation that's being had, right? Ms. Jackson, I know that you make beautiful birthday cakes, right? I've seen your website and your cakes are the bomb. Everybody says they taste good, and you do the cakes and then you do some additional cupcakes on the side. Everybody loves your service, right? So I see that and I say, hey, Ms. Jackson, my son is 22, I'm old. So my son's turning 22 in May. Can you do Spider-Man cake for him and some cupcakes on the side? So Ms. Jackson, you say, sure, that's no problem. May is 6 months away. I can do that for you. So right there, we have a soft offer and a soft acceptance. Would everyone agree? We've had a preliminary conversation. Are you able to provide this service for me? Yeah, I can do that, no problem. Cool. Now, once we got that established, I probably start asking for stuff like price, right? And you say for $300, I can make a quarter sheet cake and half a dozen Spider-Man themed cupcakes, right? And I can now accept your offer to receive $300 in exchange for quarter sheet cake and 6 Spider-Man cupcakes, right? So now what we need to do is to make sure we have mutual assent. That's the meeting. All right. Now, I don't know if you guys watch a lot of TV, but Spider-Man started looking different over the years, right? We got the all-black Spider-Man, I think his name was Venom or something like that. We got the Spider-Man from 1970. We got Spider-Man from 2005. We got young Spider-Man. So we could make a decision together on which Spider-Man I want on these cakes, right? Because I could be thinking Spider-Man 2025, you could be thinking Spider-Man 1980, right? So I get the cake and it's like, whoa, what's this? And you say, hey, you wanted Spider-Man? Yeah, which Spider-Man, right? You got to have enough conversation and enough dialogue happening to get mutual assent. I need to show you a picture of the Spider-Man I want, right? And then you can tell me more clearly on whether that's something you can do or not. I can't just leave it up to chance that you can read my mind. Because now if we go to court in that situation, well, yeah, you did provide Spider-Man. It wasn't the one I was thinking, but how can you know what I'm thinking, right? So mutual assent is based on you being able to dialogue and provide that level of information to make the off-read be able to say, hey, I can do this. Or you know what? I hadn't seen Spider-Man 2025. Let me not take that on because I don't know what it is. Any questions on mutual assent? I know I'm going fast with this stuff, but it's very nuanced and a lot of contracts go left for lack of proper mutual assent. It's not established correctly. Any questions? And I know some people are kind of doing some things there at work and, you know, caretaking and all that stuff. Anybody, please chime in. Let's get some dialogue going here. I want to make sure this is making sense to everyone.
So I would like to ask a question. This is Gwendolyn Davis.
Hey, Ms. Davis.
Hi. So I have a beauty and barber school. Also I have an online mentor. So under Square, like sometimes they pay through Square.
Yes, ma'am.
And Square was saying that I need a contract there so that, for example, if a student decide that they want their money back, you know, they can just say, I didn't get the service that I needed, blah, 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 and Square give them back their money because I don't have because I didn't have a contract there. So what type of contract would you advise, well, would you say that I need on that type of platform as far as on the Square account? So I tutor barbers and cosmetology to pass the state board exam. So, you know, and this is using as an example, if I don't
some type of service provider come. Okay. Yes. So with that, yeah, you need to. So you want some type of a service provider contract to say, you know, I will guarantee that I provide this many hours of instruction. They can have 2 coaching calls. I will visit the site they're working in for, you know, 2 visits, something like that. It gives some parameters that you can say, I can check this box off, right? You want to take as much subjectivity out of it as you absolutely can. And that's what the contract protects, because again, this this can all be in good faith, right? Tension doesn't mean that there's bad faith. It just means we didn't agree to the same things, right? So if I'm your mentee, right? And you say, hey, Richard, I'm gonna make sure that you're ready for the state boards. Well, what is it, right? What does that look like to me? So I say, okay, cool. We have some conversations. I come and watch you sometimes. I take the state board and I fail it. Well, who's right and who's wrong, right? If you can't guarantee that I'm gonna pass the test, but what you can guarantee is what you offer me. I gave you the 6 hours of instruction. Richard, we had 2 coaching calls. Richard, we went over 2 practice tests, and I told you where your areas of weakness were. Now you got a leg to stand on, right? Because you can provide all that to me, and I may never open the book to study for the state board, and I failed the test. Now I say, you know what? I failed this test. You can give my money back because you didn't put any guideline or any framework to what you were able to actually offer, right? Because that's subjective, and something like a test is emotional, right? If we leave that and we don't have a clear understanding of what you're truly offering, then we're both in limbo. So you need to kind of put a framework to what you're offering. And, and maybe that's different for every student. I don't know, but you need to make sure that there's some level of protection there for you. And generally a pretty simple service contract would be what you would need to do. And maybe that's something that you standardize for all your students, because that can get hairy, because some people are going to need a little bit more than others, some need a little bit less, but you don't want to start varying what you offer from person to person because, you're trying to satisfy everyone. Hey, my standard rate is $100. I'm going to provide you X amount of hours of instruction. I'm going to go through 2 practice tests with you. I'm going to come observe you for 2 1-hour sessions. That's what I'll do for you in preparation for the state board. And I don't know what the state board looks like, but you see what I'm saying there. All right. And Ms. Cooper, are you still there? I can't see my screen anymore. I don't know what was next. My memory's too bad.
Thank you.
All right, no worries. All right, we'll see if Ms. Cooper's still on there. Ms. Cooper, if you're still there, I can't see the PowerPoint. I lost it. So I'm trying to think what was next. There was mutual assent, there's offer acceptance, mutual assent, legal capacity. All right, so very important here. All right, legal capacity means that you have the object ability to enter into a contract and understand by that reasonable man standard again, that you are able mentally, physically to enter into a contract that you're able to perform. So one aspect of that is age. You can't contract with the person who's under the age of 18, under the age of majority, because chances are they don't really understand what they're getting themselves into, right? So age is a really big part of legal capacity. Are you all still able to hear me okay? All right, good. All right. Another thing is we know how prevalent neurodiversity has become over the last 10 years, right? There are people who have varying degrees of conditions like autism or Asperger's, all types of things that may impair their ability to appreciate what they're entering to with regards to a contract. So a person has to be legally competent for them to be held to the structure of a contract. If and the reasonable standard, the reasonable man standard assumes that everyone is in their I don't want to use the term right mind, but of capacities to where they can't enter into an agreement. But if there is something that is telltale about that person that a person may not have the ability to rightfully say, okay, I can do this or I can't do this, right? So really good example there with the elderly person. So cognitive disabilities, physical disabilities. If I'm telling you that I can paint a 2-story house for you in 48 hours, but you look at me and I'm in perhaps I'm in a wheelchair, and you don't see any special equipment and you don't ask me about any special equipment, well, chances are I probably don't have the capacity to perform what I'm offering. Now, is that right to do? No, it's not, but it is something that could come up in the event of a dispute. You say, you know what, Ms. Wilson, I know you saw this person, what made you think, what did they tell you that made you think that they could paint a 2-story home when you see that they're confined to a wheelchair? What did they tell you? Did they have crew? Did they have special equipment? What's the plan there? All right. So there's some onus on both sides there with, how legal capacity is interpreted, right? But mostly it's going to be conditions of the mind. So like I said, those are neurodiverse situations where a person may not, be able to appreciate the nature of what they do. What if there's someone who has a cognitive disability, and you got like a 4-acre yard, and they say, hey, I'll cut your yard for $20, and they get out there with a push mower and they do it, but is that right? Do you walk away from that transaction feeling like you did the right thing? Well, probably not. So legal capacity is something that it does come up, and it can kill the structure of a contract if it's not properly considered.
Can you make that a clause? I'm sorry.
Yeah, go ahead. No, go ahead.
Can you make that somewhat of a clause in your contract when you're making it up, so that this way they will have to initial that they are,
Capable.
Yes.
You would do it to the positive and not to the negative. You would say something like, I have no reason to believe that Richard cannot perform the duties of this contract at the time of signing, right? Or Richard has given me adequate assurances that he is able to perform the duties of this contract as discussed, right? You can't say, Richard, please initial here that says that you don't have a neurodiversity, and maybe I don't know I have a neurodiversity, right? Maybe that comes out later. But what you want to do is put something in there that says, it's called adequate assurances, and then there's a converse to that too. I can't think of the name of it right now. We can get back to that another time. But what assurances have I given you? Just say that I am able to provide the services that I'm promising you. All right, I see a hand up, Ms. Edmond. And Ms. Cooper, we can go forward on the next
Yes,
slide.
no, I'm sorry.
No,
So
you're fine.
will a reasonable accommodation be applied to this also? So if someone says they're gonna do something, and let's say they do have a handicap or something that's not visibly deficient, and should we give them a reasonable accommodation of time or?
Mhm. And that's a great question. So reasonable accommodations falls under the American with Disabilities Act, which is a federal law. If you can, if it's not going to hurt what you're doing, and you're led to say, hey, I like the work that this person is doing. It might take them a week longer to get it done, but I like the finished product of what they do. That's totally up to you. But you want to make sure, again, in those preliminary conversations where it's still a pretty soft contract, hey, Richard, I noticed that you have X, Y, or Z condition. will you be able to get this done in the 4-week time frame that I needed to get done in? And if I am of cognitive capacity and I say, yeah, hey, no worries, no problem, then that's on me. Onus is on me, right? You've done what you needed to do. Hey, we signed a contract. Nothing else is really needed. But it kind of comes to those preliminary conversations and reducing that language into the 4 corners of the document. Does that make sense?
Yes, thank you.
Okay, all right, perfect. All right, Ms. Cooper, if we can move forward to the next slide. And I know we're running a little close on time, but I'm in no rush. So if you got a few extra minutes, please hang with us and we'll try to get through this. And like I said, I want to get to any questions you all may have, but hopefully you've been asking them along the way. So. I know Ms. Cooper's working on that. Let me see if I can
You
find
all
that.
don't see the slide? You don't see the slide up?
Yeah, we see it hadn't moved forward. We're still on formation.
Moving forward?
Yeah.
Okay. Is that the correct slide, or should I still be moving?
No, we're still on 6. If we can go to 7, it's still showing 6 on my end.
Really? Hold on.
Yeah. Okay. But it's also showing like the download thing on your screen as well. So maybe it. What questions we got while Ms. Cooper's getting that back up for us? Anything fuzzy so far? Anything not hitting home for you right now? All right, y'all gonna make me think I'm doing a good job. All right, let's keep going forward. Still showing 6 for me, Ms. Cooper. I'm gonna see if I can, while you work on them, see if I can pull up on my end. See if I can. Okay, there we go. All right, perfect. So consideration. Has anyone ever heard of consideration in regards to contract law? Anybody?
Two parties in agreement to form a valid.
No, I've never heard of it.
No.
All right. So let's do this quick example. So Ms. Wilson, same garage, right? I come over and I say, Ms. Wilson, we've been friends for a long time. I'm so proud that you bought your new house. I'm gonna paint your garage for you for free. You don't have to buy paint. You don't have to buy materials or anything, right? I get out there and you don't like the work I've done. Do we have a contract or
No.
do we not?
Mm-mm.
We don't. Why not?
Because you just offered to do it for me. I didn't ask you to. You just offered.
Okay. So the law can consider that a gift without consideration. Consideration is the value for the exchange. Usually payment. Usually it's payment. Okay. I see someone said soft contract. Yeah, that's a preliminary conversation. That's what I kind of refer to as a soft contract, Ms. Palmer. Good question. The conversation that says, hey, I seen your work. I like what you're doing out there in the community. Hey, I want to do something with you. Let's talk about it. Then we kind of go into a real contract. So consideration is the value for the exchange, right? You put something up, I put something up. We both got something to gain. We both have something to lose, right? If I paint your garage and you give me $500, we have a contract because there has been consideration. There has been a valuable exchange, right? There's been a value assigned to service, and then I'm expecting payment for that service once the work is complete and you're satisfied with it. All right. Now, does that make sense? Kind of going back to the cell phone example, right? We said, I'm gonna pay you $200 a month, T-Mobile, but I want my internet to work, I want my phone to work, I want to get my text messages, right? That's consideration. That's the value for the exchange. Uh, the value for your exchange is you get phone service. The value for T-Mobile is they get your $200 every month, right? That's the value for the exchange. Now, some businesses exchange services between each other. Still consideration, because that additional service probably has monetary value to it. Hey, I'll bake the cakes for your birthday party if you can come paint my garage for me, right? Still consideration because there's a value on both. There's a value to baking the cake. It's a value to painting the garage. Yeah, money didn't exchange hands, but there was a thing of value that was exchanged or promised. So in the event that there's a breach or there's a failure between the two, you still follow that same legal recourse. All right. Another form of consideration that people don't think about, there's a case from like the maybe the 1940s. It was a grandfather and he had a grandson who he loved, and he wanted to keep this kid on the right course. So back then, the age of majority for like, like buying like alcohol and cigarettes was 18. So he wrote a contract and said, son, grandson, if you refuse to smoke cigarettes or drink alcohol once you hit the age of 18, when you turn 21, I'll give you $10,000, right? So the grandson didn't drink or smoke or anything until he hit the age of 21, and he says, grandfather, I want my money, right? Was there a contract there? Was there consideration in this case?
Yes.
Okay, tell me why. What was the consideration?
That he was going to give him the money when he got a certain age.
Right. And what did the grandson do?
He said, okay, grandpa, I'm that
Right.
age, I want the money.
But his abstinence, because he had a legal right to go out and drink and smoke, right? But he didn't because of what his grandfather said. If you don't, I will give you this. So even his abstinence was consideration in that case, right? So let's bring this back modern day. So Ms. Wilson, I'm painting your garage again, right? I'm finishing up a job, Ms. Wilson, and I can start on your garage November 1st, and I'll be finished November 15th. Cool?
Yes.
Cool. All right. I'm finishing up the job that I started. I'm finishing up that job. You see me painting on the wall because I'm a visual thinker here. All right. So I'm painting the garage I'm currently working on, and the job takes longer, right? So now I get to November 7th, I get to November 8th, Ms. Wilson, I hadn't started your job yet. You say, you know what? I need to get this done because the holidays are coming up and I don't want my garage looking like, like it does. So now you go and you find somebody else and you say, okay, Richard, we agreed on the price of $500 for you to paint my garage, but now I got to go out and find somebody else. And because it's so close to the holidays, they're going to charge me $1,000. Right?
Right.
That can happen, right? That does happen.
Yes.
Right? So we go to court. What can you sue me for? You abstained from hiring another painter earlier on that probably could have done it for the price range that you wanted it to get done in, which I promised you, right?
Right.
And then because you abstained and waited, now you got to pay more because I wasn't able to complete the promise. So
we have a comment in the chat that says $500 from Ms. Palmer.
Exactly right. That is exactly right. Because you mitigate the damages, right? You take the $500 that you would have paid from the original contract and you say, you know what? Because you didn't follow through on what we promised, it's going to cost me $500 extra. So, yeah, you got a cause of action for $500. Nicely done. Nicely done. All right. So, in order for a contract to be valid, there has to be consideration. Now, very rarely will a contract fail for lack of consideration? But it does. You guys have seen where family members sell somebody a piece of property or a car for like $1 because they love them. You know, hey, it's my son. I'm selling you this car for $1, or I'm selling you this piece of land for $1. Well, that dollar is consideration, technically, right? There's legal capacity, but there's also affinity. There's love and care for this person. Now, do I expect them to sell me land or a car for $1? No, they're gonna get the rightful value of it. But consideration is necessary for the validity of a contract. Does that make sense? If not, what's fuzzy about it? Tell me. All right, let's keep going while we wait, Ms. Cooper. Let's jump to the next one. If any questions come up on this, please just raise your hand. Let me know. All right, breach. We kind of been talking about breach the whole time. What happens when a contract goes wrong, right? That's breach. Generally, and I'm kind of speeding up a little bit just because of time. Generally, when there is a breach of contract, there's a remedy at law and there's a remedy in equity, right? A remedy at law will normally end up in monetary damages. So the situation with the garage just now, Ms. Cooper, who's the person who said that the cause of action was $500?
That was Katrina Palmer.
All right, Katrina, really good answer on that. Yeah, exactly right. The remedy at law is $500, right? But what if the $500 doesn't mean that much to Ms. Wilson? Then she's going to look for a remedy in equity. She's going to look for something called specific performance. Yeah, you passed due on that first job, but I do like the way you paint, and I still want you to paint my garage, and I still want you to do it for $500, and I still want it done in the time frame that you said you could do it. That's specific performance. That's a remedy of equity. I'm not looking for money. I want you to do what you said you were going to do, right? Remedy at law generally looks for monetary damages. A remedy in equity will normally look for you to do or not do something. Not doing something is an injunction, injunctive relief. For me to want you to do something is specific performance. All right. So always remember, if somebody offers like a specialty service, something that you can't go just anywhere and get, you will probably want as a form of relief specific performance. You still want them to do that thing because you can't just walk down the street and find it anywhere. If it's a pretty common service, not fine. You'll be like, I'll sue you and I'll take the money and I'll just go somewhere else and get somebody else to paint my garage. If somebody's doing something specific and it's like customized work or not everybody offers it, you want that remedy in equity. And you said, all right, I want you to do what you said you would do. Right, Seven, that's right. To make whole, back to item of service, exactly right. I don't want my money back. I want you to do what you said you were going to do, right? Money isn't always the end all be all in a breach of a contract. If, like I said, if it's a very specific service being done, specific performance will be the way that you will get that service done. And again, you still want to have a contract in that. All right, what questions we got? I'm trying to go a little faster because of time.
As of now, we don't have any chat, but people may want to come off the mic and act.
Okay, sounds good. We've talked about, kind of what breach is. We talked about financial risk. We talked about damage to relationships. We talked about legal consequences, right? These are all things that happen when contracts are breached. When you promise to provide a service or provide a product and something goes wrong and you can't or you don't, these are some of the things that can happen. But always remember, like Ms. Edmonds said, you got to look to make that person whole. What position were they in before they ever signed a contract with me? That's what the law does. It looks to put that person back in the position they were in before that contract was ever signed. So, Ms. Wilson, I'm gonna go back to the example of me painting your garage. You go out and you hire me and I say, all right, you know what? I'm only gonna charge you $300, but if you can buy the paint and the brushes for me, that'd be cool, right? You go out and you buy the paint brushes and I tell you, I get out there and I'm not right with it, the work doesn't look good, and you take me to court and you're like, look, man, the consideration I gave was $300 to buy the paint and the brushes for him, and he said he would provide this level of service. He would do this for me. All right, the judge is gonna say, well, let me see pictures of the garage. He's gonna look at pictures of the garage and say, oh man, this is really terrible work. Let's get you back to where you were before you ever signed that contract with Richard. So Richard, you need to pay Ms. Wilson $300, put her back to where she was, and then she can go on and find somebody else to get that work done. That makes sense? All right.
It does.
Ms.
Thank
Cooper,
you.
all right, let's push forward. All right, so here's what we were talking about, the equitable remedies, right? Injunctive relief is when you want somebody to stop something, right? Specific performance is when you want them to do something, all right? So specific performance, think about a specialized service, right? You got somebody who does lawn care and they actually know the chemical makeup of the soil in your neighborhood. They know which flowers grow well there. They know what they're doing, right? They contract with you to do your yard, 6 times a year, every 2 months, and something happens and they only do it 3 times that year versus the 6, right? Well, maybe you don't want your money back going forward, but you say, hey, I still want you to do my yard and I want you to do it. And the quantity and the cadence and the rhythm that we said, every 2 months you were going to do my yard. I still want you to do that, right? Cool. When you think of injunctive relief, this is a little heavier, but it's when you want somebody to stop doing something. Okay. Generally, a contract is broken for somebody not performing the way that you are expecting them to perform. So, Ms. Wilson, you hire me to paint your house, right? And we talk about the fee and we talk about time frames and all of this stuff, right? So I get out there and I start painting, and on day one, you're like, Richard, I don't like the way this work is going. But me having a little bit of knowledge of contracts says, well, if I stop, she's gonna sue me for breach of contract. So I'm gonna keep painting, right? Now you want injunctive relief. You want me to stop. You want to make me stop. You want the courts to tell me, hey, Richard, stop doing it because she's not happy with the work, with the level of work so far, right? You want me to stop. Whereas specific performance says, I want you to keep going. Injunctive relief says, I want you to stop doing something. Does that make sense?
Yes.
So you would file an injunction and say, hey, don't put another brush on my house. Don't touch my house. Don't pull up in my yard no more. I don't like the work that you're doing. This contract is in breach, right? You want to have injunctive relief first to say, okay, this is why I told him to stop. He came to my house and he was drunk. He was sleeping on the porch when I came home from work. I don't want him to do the work anymore, right? I want him to stop. I'm gonna try to keep going because I want to get paid. I took on the work, but if I'm not performing to the level that you expect me to, then you can file for injunctive relief. I want you to stop doing what you're doing. I don't want you to go any further. Contract is in breach. It's done. We're done. Does the two make sense?
Yes.
Okay. Any questions from anybody on the two? So again, the purpose of these is to ensure fair business practices. We want to protect both sides of the contract, right? If I'm doing the work and you don't like the way that I'm doing the work, okay, what's reasonable here? Can I change one of my techniques or my methods, or is the contract just done, right? Or at the same point in time, is this a job that's so specific, service is so specific that only I can provide it, and I'm telling you that I'm not going to do it? Can you sue me to continue doing the work that I contracted to do? All right. If any questions come up from that, glad to take them. Let's Cooper, let's go forward. Let's try to get through here. All right, so this is the part that I told you was kind of an intersection between civil procedure and contract law. Now, the reason why I bring this up is because some of you guys offer products that you may, or even services that you may offer outside of the state of South Carolina, right? When you extend your service outside of the state of South Carolina, you are now under the contract law of whatever state you have made yourself available in. So let's just say, Ms. Wilson, you're making the cakes again, right? And somebody goes on your website and they're in Kentucky and they say, oh, I love the cakes that Ms. Wilson is making down in South Carolina. I'm gonna place an order via the internet and have her make a cake for my son's birthday, right? Well, Ms. Wilson, you'd be like, oh, cool, man, somebody's seeing me outside of South Carolina. My business is about to expand. Well, maybe what you don't know about expanding outside of South Carolina is how you ship a cake. How are you gonna get that to Kentucky? How are you gonna make sure that cake is still in good condition when it gets to Kentucky, right? So I get that cake in Kentucky and I'm like, oh my God, it's spoiled. The icing is molding. It wasn't shipped properly. So I'm going to the court in Kentucky and say, hey, I bought this cake from this vendor in South Carolina, and when it got to me, this is the condition, right? So minimum contacts, purposeful availment. So when you think about how we do business now, like the internet, right? It's changed the way we do business. So it's not so much of me going to the mom and pop shop that I know. Hey, I can sit on my phone at night and order stuff from halfway around the world. Well, what is that looking at? Am I gonna like what they sent me? What's the recourse if I don't like, right? Because they are gaining an advantage by being able to offer their business, their products and services in a location outside of their home territory, right? The risk is now you fall under the laws of that state that you're doing business in. So you can't just think that, hey, I made the cake, it was good when it left me. No, it goes much further than that, right? So this is kind of an intersection between civil procedure, which talks about domiciles and where your area of business is, where your scope of business truly is. Lots of businesses incorporate in Delaware because the taxes are cheaper, right? The startup fees are cheaper. Okay, now what? Well, in the case of there's a dispute, what role does Delaware play in your dispute? Yeah, your principal place of business is South Carolina, but you're incorporated in the state of Delaware for the advantages that you have for startup, right? You have to keep all of that in mind when you're dealing with contracts and offering products and services outside of a certain designated area. Now, I hate to go so fast over this but I want to be respectful of time. Does that make sense? You have to really understand the role that technology plays in contract laws now, right? Sometimes I order stuff and it comes from Japan or China, and I see a jacket or some shoes, and I get the shoes and they're too small for me. I'm like, well, what's this, right? They got to have some type of policy that protects me as a consumer, right? Otherwise, they breach the contract. They sent me something that wasn't up to expectation, and I've sent them my money. So we still got that consideration there, right? That's formed the contract. I purchased something, I sent them money. They're supposed to send me that product. That's the bargain for the exchange. If the exchange isn't right, then if it's somewhere outside of that home territory, it gets a little more fuzzy. It's a little heavier to deal with. All right. All right. Any questions on this? All right. We got one more slide. Let's jump to it.
I do have a question. It doesn't have anything to necessarily do with contracts, but since you talked about e-commerce or marketplaces, how important are policies on websites?
Extremely, extremely important. And what you will normally see, Ms. Cooper, really good question, is some type of arbitration clause. So if I'm in Kansas, Ms. Cooper, and you're in South Carolina, and you order, I don't know, a cake from me. Let's go back to cakes, right? You see the cake, you like the cakes I'm selling in Kentucky. You order a cake from me, and I send the cake, but I don't do FedEx overnight because it's too expensive. So I freeze it best I can and put it in the regular mail to get to you as best I can, right? Uh, Usually on the bottom of that contract or on that form, I'm gonna say, if in the event of a dispute, we agree to binding arbitration or mediation, or we will follow the laws of the state of Kentucky, which is in favor of me because I'm the master of the offer, right? But generally, you will see a binding arbitration or mediation clause on the bottom of those sites when you're doing e-commerce, because they don't necessarily want to go to court because it's hairy. So they'll say, hey, we have a team of arbitrators here, and they will make a decision on this dispute. But 90% of the time, if you pay attention to those e-commerce sites, there is a binding arbitration, binding mediation clause in there that kind of protects them and makes their process a little bit easier. Because imagine me as a small business owner having to come to South Carolina to defend myself in a dispute over a cake, right? That cake probably ain't worth that much to me, but in order to protect the reputation of my business and to kind of explain my share, I'm gonna have to get on a plane and make travel arrangements, pay for accommodations, and hopefully it goes right. So that's how business owners normally protect themselves who are doing business across state lines. Really good question. All right, and wrap up. Importance of contracts, contractually defined rights and obligations. It just really cleans up the agreement. Are we agreeing to the same thing? Is that mutual assent there, right? Prevent disputes, right? Disputes are expensive, they're time consuming, they cause friction. People have so much access to information now that people may say, oh, look, they got 4 disputes open. I don't want to do business with them. Looks like they're causing more trouble than they're doing good. And maybe that's just the total opposite, but that's the narrative that's being spun because we didn't protect ourselves with the value of a contract. And supporting business growth, well-structured contracts, when they're executed right and people are satisfied, that's when you start getting the good reviews. You start gaining confidence in the community. People are like, you know what, that's a really good product there. I think I'm gonna try it. Or I like the way she does her business. Let's give this business a try. Even when you're like going after funding, like for grants and stuff, they want to see a level of performance and a level of expertise in the product or service that you're offering. And if that's done, hey, that opens you up to even more benefits for your business.